And good morning, everyone. It's 9:03, and I, as chair of the select board, will call this meeting as the special meeting of the select board to order Wednesday, December 21st at 9:03. We have one topic on the agenda this morning. Let's see, we need to start with the procedures. And I don't see that Rusty's here, so we'll go ahead with just explaining that the way that we run our meetings is with civility and kindness toward our fellow citizens. And note that because the nature, there's only one person from the public in the room with us here. That's Steve Lemke. Everyone else is online. So when we get to the comment period, if you have a comment, we ask you to use the raise hand, and the chair will recognize people in a reasonable order. So the agenda item this morning is an allegation before the select board. It's an allegation of open meeting law, and I will read a short statement, and then we will have a motion from the board. And once there's a motion, then there will be an opportunity for community comment. All right. So bear with me as I read, please. Thank you very much. On December 15th, 2022, Jason Heron alleged that Select Board Chair Zon Eastis and the Town of Guilford Select Board violated the open meeting law because at the end of budget workshops on October 27th, 2022 and December 1st, 2022, Eastis asked the Select Board to please stay on after the workshop. As proof of the violation, Mr. Heron cites 1 VSA section 310(2) of the open meeting law, which defines a meeting as a gathering of a quorum of the members of the public body for the purpose of discussing the business of the public body or for the purpose of taking action. Mr. Heron states that by failing to give proper notice of this meeting and failing to provide the public an opportunity to participate by expressing its opinion on whatever business was discussed by the public body, the select board has violated the open meeting law. So I'll read a short response. That's what I just described is the characterization of the allegation. And the response that we have is that Mr. Heron cites the definition of meeting in quotes under 1 VSA section 310(2) as proof that Mr. Eastis violated the open meeting law when he asked the select board to stay behind after the budget workshops. However, Mr. Heron may not realize that there are certain exceptions to this definition. There are certain exceptions to this definition. Pursuant to 1 VSA section 310(3)(b), a meeting under open meeting law shall not mean any communication, including in person or through email, telephone, or teleconferencing between members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials to discuss at a meeting. In both instances, Mr. Heron references Mr. Eastis asked select board members to stay on after the workshop so that he could distribute materials to discuss at a future meeting. Gathering to distribute materials is not a violation of the open meeting law, as this does not constitute a meeting pursuant to 1 VSA section 310(3)(b). The select board members understand that after Chairman Eastis distributed the materials, if any select board member asked a question or discussed anything outside of scheduling or organizing an agenda, it would be a violation of open meeting law. As a precautionary measure, the select board will acknowledge that it understands that it may not discuss other business of the town when materials are being distributed. No actions were taken after the budget workshops that need to be voided or ratified. So, and then finally, I'll just acknowledge by saying that pursuant to 1 VSA section 314(c), when a person is aggrieved by a denial of an open meeting law violation, that person may bring an action in the civil division of the Vermont Superior Court. So I will make a motion now based on this information and the facts of the day of both of those workshops, that I will make a motion to deny Jason Heron's allegation at this moment, and that the select board approve a letter to be written to Mr. Heron advising him of this denial and of the information. Is there a second?
Second.
Veranda's hand is up. All right. First, I'd like to see if there's any discussion that we need to have here among select board members.
Yes, I'd just like to point out that this is a number 9 allegation. Is it, Zahn?
Yes.
Thank you. Yeah.
Yes. This is the 9th allegation. Is there, I will just remind select board members to cast back in their memories and of those 2 meetings that the point of those 2 meetings was in order for me to pass information to the select board only so that they would have information for an upcoming meeting. And that's what we were doing in both of those cases. All right, Veranda.
I have a comment. Yeah, I would love it if our community could express a little bit of trust toward our select board. There'll be elections for select board members coming up, and they'll be able to replace us if they, or some of us, if they would like to.
Thank you, Brenda. I'd also like to just acknowledge here that in my experience as select board chair, which has not been very long, but I can report that several times members of the community have spoken to me either via email, in person, or on the phone about having questions or issues that they thought they wanted me to check on about how we're doing and whether or not we're following appropriate statutes, whether or not we're following open meeting law. I really have appreciated those conversations because it's an opportunity for me to talk with the select board member, the community member, and express what my understanding, and then learn from them what their understanding is. The situation we're in now does not allow that kind of conversation, and it puts the community, as we are seeing now, in a certain rigor that is, in my mind, not altogether helpful. So I just would like to say that. All right, so I will now take a comment from the community. I see that Jason Heron's hand is up, and Barry, I see yours.
Thank you, Mr. Chairman, select board members, for showing up 9 o'clock on a weekday. You're citing 1 VSA 310(3)B as your reasoning for not following the statute. That doesn't mention anything about a quorum. That's the difference. Is you're allowed as a select board member individually to contact the other individual select board members, and you are allowed to discuss and hand out information and all of that individually. The moment you have a quorum and you're discussing public business, that's when you're violating the meeting. So on that day, you gathered as a quorum. There's no denying you gathered as a quorum.
Correct.
And there's no denying that you discussed the business of the town, though we don't know exactly what you discussed. You are saying that this is what you discussed, but this is why we have this open meeting law. So we don't have to ask. We can just look on the record. Now, when you cite 310B, you are saying that 310(2), the one I'm citing, is not valid. Well, that's not true. You met as a quorum. Is that correct? Was there a quorum there?
Yes.
There was a quorum, and you discussed town business. Is that correct?
No, we did not.
What did you discuss? Did you discuss like how, what were you fixing on your house? Yeah, you discussed town business. You handed out business of the town. You discussed town business. If you didn't discuss town business, then why did you ask the select board specifically to stay after? Why not talk to someone else? I mean, you met as a quorum. You discussed town business. You meet the definition of an open meeting. This is conspiring, and there's a reason why we do this. And people can conspire for good reasons, and people can conspire for bad reasons. But the fact is, this is an open meeting violation. It is so clear that you met as a quorum, that you discussed public business, that is defined as a meeting, that you did not duly warn this meeting. This is open and closed. And the fact that you go to 310B and say this is your excuse, when they don't mention a quorum in 310B, they're just saying a meeting between individuals, which is, no one's denying that. I'm not denying Mr. Eastis has the ability to contact other select board members individually and hand them out information. What I am saying is they cannot meet privately without publicly saying in an open meeting. And there's no denying this. The fact that you're trying to use a different statute and confuse the public with the definition of the term meeting is completely, it's so misleading. And this is why I don't trust you. I mean, you say that I should just trust you. Well, and look, I've gone over and over with this, but this is a meeting violation. This is so clear.
Thank you, Jason. Thank you.
I mean, in my time,
Barry
Aleshnik, I'm asking direct questions.
Barry Aleshnik, thank you.
Thank you. I just want to say in response to what Veranda said that I, for one, have a great deal of trust in the select board to conduct the business of the town and to conduct it with integrity. Knowing you all as volunteers, neighbors, I feel that trust is warranted. So I would just like to underscore what Veranda said on this matter. Thank you.
Thank you. All right, and in the room, Sheila Morris would like to say something. I'll turn the camera around. So
yeah, so I just want to speak as a former select board chair, former planning commission member, and current whatever I am, assistant town administrator. Several years ago, Veranda, Michael, I, other people, we attended more than one training on open meeting law. We, for years, have not shared information in emails to select board members or in conversation, whether or in a group, whether we were in a quorum or not, without saying at the beginning, do not discuss this, do not reply all, because we are keenly aware of the appearance of having discussions that might be construed to lead to either taking actions or making decisions, and that does not and did not happen. That's all I need.
Thank you. All right. I see no other comments. Steve Lemke is here in the room. He'd like to say something.
Steve Lemke, River Road. On page 4 of a guide to open meetings from the Vermont Secretary of State, under exceptions, for the purpose of the open meeting law, meeting in quotation marks, does not include the following: any communication between members of a public body, it doesn't say how many, it just says there could be 100 or 2. Any communication between members of a public body for the purpose of scheduling a meeting, organizing an agenda, or distributing materials to discuss at a meeting, provided that no other business of the public body is discussed or conducted. So I'm not going to debate it. I'm just reading the facts here, that if I were to interpret this, it would say that it makes it possible for the select board to sit down together, to form an agenda, distribute materials for future discussion, provided that no other business of the public body is discussed or conducted.
The key to that, Mr. Lemke, the key to that is the quorum. A meeting can take place between 2 individuals, but when there's a quorum, that means it needs to be publicly announced. So what you're reading there is exactly what Mr. Eastis was reading, which was 310B, which is saying that, hey, an individual select board member can meet individually, and they can meet with 1 at a time. But as soon as they have 3, they have a quorum. As soon as they have a quorum, that needs to be publicly announced. That's the difference between the 2 definitions. One is talking about a quorum, and one is talking about an individual meeting.
Okay, Jason, I'll just step in. I'm going to ask you not to respond any further. As you will know,
this is about me and my complaint. How am I not supposed to respond to that? That's ridiculous.
Jason, I only meant that I didn't want you to interrupt me while I'm trying to explain this to you. So if you'd sit quietly and listen to me for a couple of minutes, I would appreciate that.
I can't address me today.
Yeah, and you can't speak directly to Steve Lemke. You need to speak to me when you have any issues. I am operating this meeting. Thank you. As you well know, because this has happened in previous allegations that you have made, Vermont statute is not crystal clear in representing every single issue at every single point. Sometimes it requires that you understand more than one aspect of the open meeting law and put them together to make sense. So that's exactly, in this case, what has happened, that it's the open meeting law states that whenever members of a body get together, it doesn't talk about a quorum, but it doesn't presume that either. And if it did need to presume that, then it would want to make reference to, it would say, except in the cases of a quorum or something like that. So the fact that we're getting together is perfectly okay by statute. And that's what we've been advised by our lawyers, and I'm sorry that you disagree, but at this point, the select board will be denying this allegation because as we understand it, it's perfectly okay for us to get together simply to pass information so that we can continue the business of the meeting. It's what we do via email. It's what we can do over the phone. We can do that together. All of us sitting down to do this. We can do this. So I'm sorry that it's distressing to you, but this is the case. And I will call on Richard Wazansky.
Yes, I'd just like to underline that this has been reviewed by our attorney at expense once again, and that if Mr. Herron has a problem with the decision, as you read out in your statement, Zahn, take it to court, Vermont Superior Court.
Right. I'm sorry.
That is the sought remedy for you, Mr. Herron.
Right, that is the remedy. The remedy is, since we have this very formal allegation before us, the next step is that the select board acts upon it. The remedy is that if you're not happy with this decision, then you can take it up. You can take it up with the civil division of the Vermont Superior Court. That's the formal structure that's laid out by the allegation that's been created by you. So we're only following that allegation. We don't have the statutory ability to sit and discuss with you about whether we're correct or not. Our legal advice has told us that we are, in fact, okay in this situation. At the same time, we're learning all the time about issues. We are learning and correcting ourselves as we go forward. If you need to feel that we're correcting you, then and you're not happy with it, take it to the Vermont Superior Court. That's the situation. We can't discuss it any further because we will be making our decision momentarily. And if you're not happy with that decision, the motion that's on the floor, please take it to Vermont Superior Court. If you need a floor in order to explain to people why you're correct about this, then develop your own floor, your own stage. We don't need you taking up select board time in order to convince the community about how bad we are at running the community's work and business. That's what we are elected to do. That's what we are doing now. So we will take the vote right now about whether or not to deny this allegation.
I'd like to make one comment.
No.
I listened. I know I saw Miss
We're done.
Are
I'm
you
sorry.
telling me?
Make
Ms.
it.
Morrison,
Well,
are
I'm not
kidding
telling
me?
you anything.
You're going to shut me
Excuse me.
down. You're really going to shut me down. You're talking about bullying. You guys are bullying me from public discussion right here. Ms. Moore said clearly
I would like
that
to
she's
take
not
the
allowed
vote,
to reply
please.
all
I
the
call the
emails.
question, please,
I
and let's
personally
move on to the vote.
I would like to
Mr.
take the vote.
Rosansky, you are out of line, sir.
I would
This
like
is
to
a point
take
of
the
order.
vote,
This is
please.
my chance to talk. You said for me
I
be
would
quiet
like to
while you were
take the vote,
talking.
please.
This is my chance to talk.
I will
Are
take
you
the
not
vote.
allowing me to talk? You are
Let's take the vote.
infringing on my First Amendment rights, my freedom of speech
All
right now.
Michael,
You're telling me I
take
can't
the vote.
talk?
Michael,
Aye.
Unbelievable.
Aye.
This is a farce.
Richard?
This is unbelievable.
Aye.
Brenda says aye.
Aye.
All right. And Rusty.
Rusty is here too.
Yeah, Rusty. Aye. Rusty says aye as well. And Zahn says aye. So thank you. The business at hand is that we have denied this allegation, and Mr. Herron has the statutory right to take this up with the Vermont Superior Court. That's the next appropriate step if that feels like it's important to him. So thank you very kindly, folks. I will now ask for a motion to adjourn.
So moved.
Thank you, Richard. A second from Veranda. I will take the vote. Michael,
Aye.
Richard,
Aye.
Veranda,
Aye.
Rusty,
Aye.
and Zahn says aye. Thank you very kindly. This meeting is adjourned. Oh, my God. Now, let me just make sure. Yeah. Where is,
Are the select board members who are going to stay on after this meeting?
I can't, it's gone now and I can't find it. Just give me a
I
second.
see all the select board members staying on. Are you guys meeting again?
There's so many things here that I can't, here we go, Zoom. Okay, and